Wait, please, Your Lordship. I beg to mention item number 12. Item number 12. As the conducting counsel is out of station.
On preliminary appellant, this is matter of the 2 weeks.
May I please, Your Lordship? Your Lordship, I beg to mention item number 14, Your Lordship. I'm praying for 2 weeks' time, Your Lordship, due to some personal difficulties, Your Lordship.
On preliminary appellant, this is matter of the 2 weeks.
Highly obliged, Your Lordship.
Please, Lordships, I beg to mention item 13. Lordship, I prefer 2 weeks' time in this matter. 13.
I have no objection.
Aju, 2 weeks.
2 weeks.
Please, Your Lordship, I beg to mention item number 10, Your Lordship. I pray for accommodation, Your Lordship, as the conducting counsel is indisposed, Your Lordship. Item number 10.
No objection.
2 weeks.
Much obliged, Your Lordship.
Wait, please, Your Lordships. Lordship, I beg to mention item number 15. Lordship, learner DSJ is out of station.
What is this matter about?
This is denial of the benefits to the serving employees in the agreements. Similar relief given to other employees in other institutes. And even GAT has a part of in our favor. A number of times on my other sides has taken time. We pray for all as a last chance after 2 weeks. Well,
Because service matter usually you should not delay.
yes.
Who's appearing in this case?
My
Dr.
late
Muzika?
friend, Mr. Muzika is
Dr. Mozika.
He's not here.
No, Lordship. He's out of station, Lordship.
On pre-made by D. When is he coming?
Lordship, I'll pray for 1 week's time.
1 week?
As a last chance, Your Lordship, because there's a revision of pay.
On pre-made.
Well, after 2 weeks in that case, ma'am. After 2 weeks, Mr. Last chance.
Accommodation has been sought for on behalf of Dr. N. Muzika, TSGI, who is said to be indisposed. The still not be objected to by the respondents. Matter is adjourned. As prayed for, this is matter up to 2 weeks.
Much obliged.
But if we tell them,
Please, Lordship. Lordship, I beg to mention this item number 9, Lordship. So this is a POXO matter, Lordship, and here, Lordship, the matter is still pending before division bench, Lordship. Before the Supreme Court also, Lordship.
division bench.
There's another division bench consisting of Justice Thank You and Justice IP Chief, Lordship. There's one matter also which is related to this matter. That issue of consent is involved, Lordship.
But why
That
would
was referred by the single bench, Lordship. So that issue is pending, Lordship. And even in Supreme Court also, that matter was last listed on last month, Lordship, on 6th May, Lordship, and the next date, Lordship, is not showing here, Lordship. So
but we cannot just put on hold these matters just
yes,
because.
Lordship, but that issue is similar issue, Lordship. Similar issue is involved, Lordship.
Mr. Guru, you find out.
Yeah,
whether
I'm aware of that, my lord.
in the light of the present situation, where matters before coordinate bench,
Yes, Lordship.
whether this court can
My
take up the matter.
lord.
The principle may be the same, but facts would be different.
That's different, but that similar issue, Lordship. Similar issue.
Consent.
Consent, Lordship.
even if the matter is pending before Supreme Court, it doesn't mean that this court cannot take up. There is no bar.
No bar.
Or is there any
There's
specific
Lordship
direction
is
by
right. Lordship
Supreme
is
Court
right. There's no stay.
that until and unless the matter is decided by Supreme Court,
Yes.
all other matters in all high courts dealing with such issues
There is
cannot
no
be taken
bar.
up?
There's no.
It takes simple time.
So 2 weeks, Lordship. 2 weeks.
Did you look into it
My lord.
on pre-made by the appellant? This is matter for 2 weeks.
Deputy Organizer.
My lords, I beg to mention item number 2, my lord. The legal aid counsel is unable to pay, my lord, due to personal difficulties.
This matter is almost completed.
Almost completed, man.
My lord, the legal
The appellant has been heard.
Heard
He has concluded his argument.
some queries were there. He was supposed to.
This is that murder
Procedural.
case
Yes, my lord.
by their wife.
My lord.
Wife or sister or
His sister and brother-in-law.
sister? If it keeps, being adjourned like this, we'll forget
Exactly.
what are the facts. Then you have to refresh the court. Then it goes on and on.
Since he's taken.
I think I read yesterday in the news somewhere. Matter was pending for 17 years.
Oh,
Was it 17 years or I don't know? Some high courts. When the Supreme Court went through the issue, it is this because of this adjournment, roster change, new judge comes, all those things, then it piles up. We should not fall into that trap.
My lord, the matter may come after a week, my lord.
Pre-made by the appellant, this is matter to 1 week.
the plea.
Terry, you can quick
May I please lodge?
next week first item anymore. Talk to me,
May I please lodge? Your lordship, I beg to mention item number 16. Your lordship, I'm praying for 2 weeks' time. Your lordship, in this matter, we're supposed to file a substitution petition. I'll be filing in the course of the day, your lordship.
Do you want to complete a new petition, Your Lordship? You have to file an application to that.
There was also a similar matter, isn't it?
It
Yes,
came
Your
last
Lordship.
week, Lordship,
Yes.
concerning the same person.
CAG was replaced by the deputy.
Yes, your lordship.
CAG is not competent to file
Your lordship,
petitions.
it's competent, but your lordship, the DAG legal HR, your lordship, will be replaced, so it'll be more competent, your lordship.
Have you filed a petition?
Your lordship will be filing in the course of the day.
Pre-made by Ms. Pasa, the counsel for the petitioner. Matter is adjourned. Decision after 2 weeks.
May I please, Your Lordship? Your Lordship, I beg to mention item number 6, 7 and 8 on behalf of Ms. N.G. Shilla, Your Lordship. Your Lordship, she's indisposed, Your Lordship.
Your Lordship, the arguments have been concluded on behalf of the appellants.
Concluded?
Yes, Lordship.
You remember? Exactly. Now we've forgotten. Miss Leonard J has sought for accommodation on behalf of the Leonard Conducting Counsel, Miss N.G. Shilla, who is said to be indisposed. The same not being objected to by Mr. Leonard Counsel of the appellant. That is adjourned. How long?
2 weeks, Your Lordship.
This is
Lordship, may this be the last opportunity, Your Lordship. May this be the last opportunity.
I don't believe in last chance, because it will put everyone in an awkward position. Because I know next time so they'll see the same thing, and we don't have anything after last. So we have to give them some leeway. After last, this is final, my brother said. That's 6, 7, and 8.
Yes, Your Lordship.
78.
Much obliged, Your Lordship.
Daily list item number 1.
Mr. Case is Gautam Lara, counsel for the appellant, seeking accommodation. Matter is adjourned. Recess after 2 weeks.
Obliged.
No,
Supplementary list, item number 1.
May I please, Your Lordship? Lordship, I would like to withdraw this petition, my lord, because there's.
Just to recapitulate, my lord, yesterday your lordships had heard this matter at length, and we stopped at the point where I do not have the rules, my lord.
Oh yes.
Just to recapitulate, my lord, yesterday I had pointed out to your lordships that there was a dispute between two managing committees.
Yes.
Between two managing committees, and the petitioners, my lord, both the petitioners got entangled in that dispute. And if I take your lordships back to page 88 of the petition, of the third item, my lord, writ petition 456, petition number 456 of 2020. So this is the spot inquiry, my lord, which your lordships will recollect, which has been conducted by the department, Directorate of School Education, pursuant to an order passed in the writ petition. I had taken your lordships to a very relevant date, which is at page 92.
Yes.
At page 92, wherein the inquiry report speaks about the verification of records, my lord.
Yes.
And at para A of this sub-para A of para 3, which reads, my lord, that the dispute of the ownership and management of the school, that is St. Mary's RCLP School, Nongwai, was settled in favor of Roman Catholic Church by the Commissioner and Secretary to the Government of Meghalaya Education Department as per para 14, as per order issued by so-and-so, dated 30th of April 2013. So, my lord, the dispute was settled by the my lord, Commissioner and Secretary on 30th of April 2013. It was pursuant to this, my lord, that the petitioner was suspended, my lord, which your lordships will find at page 86. So it is pursuant to the order passed by the Commissioner and Secretary on 30th of April 2013 that on 13th of July 2013, the Managing Committee of the school decided to suspend the petitioners, my lord.
Yes.
And in pursuance to this, resolution, the government at page 87 on 10th of January 2014 approved the suspension of the petitioners. So my case, my lord, starts from here, my lord, that I have been suspended with effect from July 2013 till date, my lord, indefinitely, without any disciplinary proceedings. Yesterday, Your Lordships, I had also pointed out to Your Lordship the Act, my lord. And the Act at section 10 provided for conduct of inquiry, my lord, and framing of rules.
Have you brought the book with you, Mr.?
My lord, I have given the list of books, and my lord, I have just scanned the relevant
You don't
portion.
have this book with you?
Yes, my lord, I have scanned the relevant portion. So, Your Lordships may kindly have page 170 of this book.
170?
170, my lord. So, at
No, where does this thing start from?
it will contain
Page
the Act.
162.
Yes, my lord, because I don't have the book. There's no extra book from the library.
I was asking you
Yes,
just
my
now.
lord.
You said, yes, I have.
No, my lord, I have just scanned the relevant portion of the rules of this book, from this book.
Yes.
So the book will contain the Act, my lord. And at page 170 of this book, my lord, Your Lordships will find the service rule for employees of government aided schools.
Yes.
Your Lordships has page 170.
Just a moment. Yes.
Your Lordships will kindly have Rule 1. So the rule provides, my lord, appointment and dismissal. It reads, my lord, the managing committee of a school is the authority to appoint persons in connection with the affairs of the school, and as such, it is the authority to dismiss or remove such persons, provided that, number 1, all cases of appointment, bracket, except temporary appointments for not more than 3 months, dismissal or removal concerning members of the teaching or the ministerial staff of a school must have the prior approval of the inspector of schools. Number 2, no person suspected to be connected with anti-state or subversive activities or with any unlawful party, whether directly or indirectly, shall be retained in the service of aided school. No person over, number 3, no person over 60 years of age shall be retained in the teaching staff except on production of a certificate of physical fitness from a government medical officer not below the rank of assistant surgeon grade 1 with the approval of the director of public instructions. Rule 2, moral. Conduct and discipline. No employee of an aided school shall accept, number 1, accept any private employment. Number 2, any office under political party so and so. Then I'll take your lordships to number 5. This is penalties, my lord. Any of the, number 5, rule number 5, any of the following penalties may be imposed on an employee of an aided school by the managing committee for good and sufficient reasons, my lord. So these are the punishments, my lord. Now the proviso is important, my lord, on the next page. Provided, number 1, none of these penalties shall be imposed on an employee of an aided school until he has been given a reasonable opportunity of show cause against the action proposed to be taken in regard to him, my lord. Then, my lord, at Rule 6 is provision of appeal. And in relation to suspension, my lord, Rule 9. Rule 9 reads, my lord, subsistence allowance during period of suspension.
Yes.
It reads, my lord, for the period of suspension and until the inquiry is over, an employee may be allowed a subsistence allowance not exceeding 1/4 of his pay, which should be fixed by the managing committee considering the circumstances of the case. So, my lord, under the rules also, inquiry has to be conducted, and suspension, my lord, during suspension, subsistence allowance of 1/4 of the salary should be paid, my lord. So that is my case, my lord, that since 2014 till date, my suspension has been indefinite, and no subsistence allowance has been paid to me, and no proceedings have been initiated against me till date, my lord. And despite representations, my lord, they have not considered my representations. So that is my case, my lord. I'll just my lord, cite two judgments. The first judgment is of the Supreme Court, my lord, which is reported in 2014, volume 7, page 291, my lord. This is the cases of Ajay Kumar Chaudhary.
Yes.
So, my lord, I'm relying on paragraphs 19 to 21. Internal page 302, my lord.
Yes, yes.
So, para 9 reads, my lord, State of Punjab versus Chaman Lal Goyal deserves mention inter alia because action was initiated on 25th of March 1992, and a memorandum of charge was issued on 9/7/1992 in relation to an incident which had occurred in 1st January 1987. The factual matrix obtaining in that case, the court reserved and set aside the High Court decision to quash the inquiry because of delay. So, my lord, this is on delay, that any delay in conducting inquiry is also vitiated. Now, para 20, my lord. I'll take your lordships directly to para 21, my lord, which relates to suspension. Para 21.
Yes, please.
We therefore direct that the currency of a suspension order should not extend beyond 3 months. If within this period the memorandum of charge / charge sheet is not served on the delinquent officer employee, if the memorandum of charge sheet is served, a reasoned order must be passed for the extension of suspension. As in the case in hand, the government is free to transfer the person concerned to any department in any other office within or outside the state so as to serve any local or personal contract that he may have and which he may misuse or for obstructing the investigation against him. The government may also prohibit him from contacting any person or handling records or documents till the stage of his having and prepared his defense. We think this will adequately safeguard the universally recognized principle of human dignity and the right to speedy trial, and shall also preserve the interests of the government in protection. We recognize that the previous constitution benches have been reluctant to quash proceedings on the grounds of delay and to set time limits to their duration. However, the imposition of limit on the period of suspension, this is important word. However, the imposition of a limit on the period of suspension has been discussed in the previous case law and would not be contrary to the interests of justice. Furthermore, the direction of the CVC that pending criminal investigation departmental proceedings are to be held in abeyance stands superseded in view of the stand adopted by us. So, my lord, basically this judgment talks about my lord, suspension and delay in proceedings, my lord.
Yes.
The second judgment, my lord, I am relying on a Calcutta High Court judgment because In this particular case, it's similar, that suspension, prolonged suspension has been imposed without any proceedings, my lord. This is reported in 2006, volume 1, LLN, page 532. This is by the High Court of Calcutta.
Yes.
In the case of Chabi Chakravarti versus West Bengal. And the relevant paragraphs, my lord, I'm relying is from paragraph 12 onwards, till the last paragraph 19.
Para 12?
Para 12 up to 19, my lord. This is on prolonged suspension, my lord.
Yes.
Para 12 reads, my lord, the Honorable Apex Court, in the judgment of Rajiv Kumar, examined the provisions of Rule 10 with its sub-rules and got satisfied that the same is not unconstitutional. Here the rule is not under challenge, and I have not been called upon to decide as to whether the said rule has a constitutional validity or not. The expression life doesn't merely connote animal existence or a continued drudgery through life. The expression life has a much wider meaning, suspension of such type without any limitation. So it talks about suspension, suspension of such type without any limitation and without departmental proceedings, prima facie tantamounts to imposition of penalty, which cannot be done without following the principles of fair play and natural justice. Para 13. In another judgment in Ashit Kumar Sarkar, the Honorable Division Bench of this court observed that the employee cannot be kept under suspension for an indefinite period, and the employer also cannot adopt a dilatory tactics to victimize the employee. The relevant paragraph, being paragraph 5 of this judgment, is quoted herein below for convenience of discussion. So the paragraph is quoted. It reads, the disciplinary proceedings were not unnecessarily continued or prolonged because of laches and or negligence on the part of the petitioner, but because of inherent defects therein, and further, after the issue of charge sheet on October 1994, no charge sheet was given to the petitioner within 3 months from the date on which the order of tribunal dated June 22nd, 1995, and that the order of suspension was allowed to continue even after that. It was found that disciplinary proceedings was illegal. This is not the way under suspension. This is not the way under suspension, and the matter should be prolonged. Whenever an order of suspension is passed in contemplation of disciplinary proceedings, the authority concerned should issue charge sheet within a reasonable time. If the rule is silent, and the authority should conclude the same within reasonable time, cannot be kept under suspension for an indefinite period, and the employer also cannot adopt the dilatory tactics to victimize the employee. Para 14. One is to bear in mind that order of suspension also touches the right of livelihood, and provisions of Article 21 of the Constitution of India are attracted. Years together, a person cannot be kept under suspension without any departmental proceedings. Number 15. Normally, an employee is suspended to keep him away from the place of his work so that he cannot influence the proceedings which is contemplated or which is continuing. A criminal case is initiated on a charge which is in no way connected with the working sphere of the employee. The employee got involved in the criminal case, detained in custody for more than 48 hours, and he is suspended with retrospective effect for unlimited period, and he is given subsistence allowance, that is minimum food to exist in this world. Natural justice comes forward and shocks the conscience. An employee, if involved in criminal case for any reason whatsoever, will be suspended, and that too with retrospective effect, and the effectiveness of suspension or period of suspension or date of withdrawal of suspension, nobody knows. If that is not the violation of natural justice, what more it can be. Para 16. Considering the facts and circumstances of the case, I am of the view that such type of deemed suspension and or as provided in Rule 7.2 of the Primary Education Rules is illegal. Para 17. I therefore set aside the impugned order of suspension and direct the authority to allow the teacher concerned petitioner to resume his duties within a period of fortnight from the date of communication of this order. The petitioner will be paid the entire area of salaries after the adjustments of the subsistence allowance within a period of 8 weeks from the date of communication of this order. The petitioner will also be paid her salaries month by month effective from the first day of the next month. With the above observation, the writ petition is allowed. So, my contention is also the same in this particular case, that prolonged suspension has been going on with effect from 2014 till date. without payment of subsistence allowance. I'm not asking for salary, my lord. All I'm asking is from the date when I was suspended, I may be paid my subsistence allowance, my lord, and the suspension order and the approval may be set aside, my lord. Now, as far as disciplinary proceedings is concerned, my lord, that is up to them whether they still want to initiate or no. And if that is so, then I will also always have my ground, my lord, I will always have a ground to raise on delay. That will be a subsequent development. So that is my submission.
You start first, Mandi Committee.
Yes.
I don't know where the rules. Let me start first then, Lordship. May it please your Lordship. Your Lordship, first and foremost, your Lordship, my humble and respectful submission, your Lordship. This writ petition is hit by the principle of delay, your Lordship.
Yes.
Because, your Lordship, the relief claim in the writ petition, your Lordship, basically, your Lordship, is for setting aside the report of the inquiry which was conducted on the direction passed by this honorable court. Lordship, kindly come to, with regard to suspension, I'll deal separately, your Lordship. Kindly come to page 19, your Lordship.
Yes.
Lordship, the relief claim in para 4(5) of the writ petition cannot be granted, your Lordship, because this report of this inquiry was conducted on the basis of the direction passed by the Honorable High Court in the earlier proceeding, your Lordship. So far, the salary for the year 2009, your Lordship, that also has been declined, your Lordship, by the report of the inquiry. Then, so far, the contention, your Lordship, the suspension, your Lordship, the problem, your Lordship, in these cases, in my humble and respectful submission, your Lordship, the petitioner themselves, they are the makers of their own problem, your Lordship. The crisis.
Just a moment.
Lordship.
Mr.
Nothing has been said about the report of the inquiry, your Lordship. Nothing has been said, your Lordship.
You have made you advance your argument in
only on one point, Lord, that is suspension.
In case in the
246.
What about the other case?
Same, your Lordship. It's same. It's same, your Lordship.
456. It's exactly same.
Same,
school,
same, your Lordship.
2 teachers.
2008, 2009.
Common argument.
Lordship, yes. Lordship, yes.
Okay. Please continue.
So one, your Lordship, there is a delay. Then another submission, your Lordship, is the principle of constructive res judicata, your Lordship. Lordship, can you see, in 2012, a writ petition has been filed, your Lordship, and the so-called order of suspension, your Lordship, I would call it a so-called, your Lordship. In my humble and respectful submission, your Lordship, this suspension should not have been issued by the school managing committee or approved by the then inspector of school, your Lordship. Because, your Lordship, it was passed in January. Lordship, kindly come back to us at page 87. Lordship, this so-called order of suspension was passed on 10 January 2014. It should be 2014, your Lordship, not 2013.
Yes.
During the currency, your Lordship, of the earlier writ proceeding, that is writ petition number writ petition number 182 of 2012. Because this writ petition number 184 of 2012 was disposed, your Lordship, by the Honorable High Court, your Lordship, on 3/3/2014. It was pending, your Lordship, at that time when the so-called order of suspension was passed, your Lordship. This fact ought to have been brought, your Lordship, before the in the writ proceeding of WPC number 84/2012. Ought to have been brought, your Lordship. Be that as it may, Your Lordship. Be that as it may, Your Lordship. Then, Lordship, I take Your Lordship to page 42. That is the order of appointment, Your Lordship. Lordship, kindly come to page 79, Your Lordship. That is the writ petition number 84 and one is 85, Your Lordship. And the date of the decision, Your Lordship, will find at page 80, Your Lordship. 3/3/2014, Your Lordship. That means the order of suspension was passed during the currency of the writ petition, when the writ petition is still sub judice. And this fact ought to have been brought, or that writ petition ought to have been amended to challenge that order of or that so-called order of suspension. That was not done, Your Lordship. And
that order was okay.
Lordship, and that writ petition was disposed, Your Lordship, with a certain direction, direction, Your Lordship.
Page, there was the
Lordship, that report of Lordship, kindly come to page 79. Yeah. That is the order passed by the Honorable High Court in the earlier proceeding, Your Lordship.
Yes.
And the direction, Your Lordship, will find it at page 84, para 10, Your Lordship. Para 10, Your Lordship. That the report of the inquiry, Lordship, because my friend has conveniently read the report. Yes. I'll come back to that report, Your Lordship. Lordship, kindly come to page 42. That is the order of appointment in respect of the writ petitioners. This is the legal appointment, Your Lordship. In a school, Your Lordship.
Page 42.
Page 42, Your Lordship.
Yes.
She was appointed in St. Mary's RCLP School, Your Lordship. And Lordship, kindly see one copy. The Secretary Managing Committee, St. Mary's RCLP School, Your Lordship. Yeah. Lordship, it is a common parlance, Your Lordship, that Saint, Your Lordship, denotes the institution of the Catholics, of the Catholic. It is a Catholic institution, Your Lordship. It denotes, Your Lordship, Saint, Your Lordship. In my humble and respectful submission, Saint denotes that the institution belongs to the Catholics, Your Lordship. It belongs to the Catholic, and this is the school, Your Lordship, where they are legally appointed, Your Lordship. What happened, Your Lordship? What happened, Your Lordship? In 2008, Your Lordship, the dispute, the secretary, Your Lordship, at that time, one Franciscan, he was trying to split the school from the Catholic, from the Catholic. And in 2008, Your Lordship, he started making his own school, Your Lordship. And these two writ petitioners, they followed him, Your Lordship. They followed him, Your Lordship. That is why, Your Lordship, the salary during this time were not paid, and they came and they filed a writ petition before the Honorable High Court, Your Lordship. Lordship, kindly come to the report of the inquiry. It's very clear. Lordship, kindly come to page 88, Your Lordship. Yes. Page 88. Lordship, kindly see the Directorate of School Education and Literacy, Government of Meghalaya, spot inquiry report on the attendance and functioning of the teacher of St. Mary's RCLP School, Nongwa, and the SCSO, Northern West Gazelle, conducted on 19 September 2014 with reference to the High Court order. As directed by the Director of School Education and Literacy, Meghalaya, Shillong, dated so and so, I made a spot inspection of St. Mary's RCLP School, Nongwa, accompanied by Shri so and so and Shri so and so and so. The main purpose of the inquiry is to verify the attendance and functioning of two teachers of the above school, Shimati so and so, Lordship, both the writ petitioners. On arriving at Nongwa village, I was informed that there are two schools. There are two schools in the same name, St. Mary's RCLP School, one run by the Roman Catholic Church, and another school in the name run by Shri Francis. He created that another school, Your Lordship. that fake, Your Lordship, I must say, a fake St. Mary's School, Your Lordship. And two teachers, so and so, Your Lordship, and the two teachers, Your Lordship, they accompanied him, Your Lordship. They followed him, Your Lordship. Then, Your Lordship, the above two schools shall be referred in this report as A and B respectively. Detailed report is given below. A, Your Lordship, St. Mary's RCLP School, A. Firstly, I visited the original old school run by the Roman Catholic Mission, referred here with School A. The school building is permanent in nature, with 3 classrooms and a storeroom. Beside the school building, there is a kitchen shed come storeroom meant for midday meal program as well as toilet facilities. Lordship, these are the pictures, Your Lordship, the photograph of the school A. Then, Lordship, can you turn to page 89, Your Lordship, the enrollment, Your Lordship. Yes. On the date of the inspection, the class Y enrollment is indicated below, Your Lordship. Then Lordship, the teachers. The school is having the following teacher as per teacher attendance register maintained by the school. Shri so and so, then Shimati so and so. Then both the above teacher are engaged as voluntary teachers in so and so. It may also be mentioned that both the name of so and so that means they recorded in the teacher attendance but mark absent with effect from 2008-2009 till date, Your Lordship. That means at the time in the year till 2004, when the inquiry was conducted, Your Lordship, both the writ petitioner, they were not teaching in that school, Your Lordship. They did not render any service, Your Lordship, in that Roman Catholic RCLP school. Then, Lordship, kindly see the managing committee. The school is having its own managing committee duly approved by the office of the SD SEO Nostine with Shri so-and-so as the president and Reverend Kenny Pakma as the secretary with effect from so-and-so. Then, Lordship, kindly turn to page 90. As per teacher attendance register maintained by the school, the detail of the teacher is given below so-and-so, Your Lordship. It is also noted that the attendance of teacher in the school is recorded, and both the teacher are giving the school in the school B sensor a short copy of the so and so. The school is not, Lordship, kindly that school B. The school is not having a managing committee of its own duly approved by the remark. Both the above teacher has shifted to the present school B. Lordship, kindly see. On their own, Your Lordship, they left the school. They left the school run by the Roman Catholics. Has shifted the present school due to the dispute in the management of the school. Remarks, Your Lordship, kindly come to page 91. After recording the information from the school register and record as well as interacting with the student in their respective classroom, I also inspected the kitchen and where midday meal is being cooked with, which I was told that it will be served to the student after school. Then kindly see 2, Your Lordship, St. Mary's RCLP School B. That means this is a fake school, Your Lordship. Next, I visit another St. Mary's RCLP school referred herewith as School B, located about 100 meters east from the previous St. Mary's RCLP. I met both the two teachers. They were there, Your Lordship, in that school. Can you see, Your Lordship? They were there, Your Lordship. As I have submitted, voluntarily, they left that Roman Catholic school, Your Lordship. Then, Lordship, the school is temporary in nature, with 4 rooms and tin roofing. All the 4 sides of the building is also covered by the tin roof and the plain sheet. The school is not having the basic facilities like toilet, drinking water, and kitchen shed to the midday meal program. Then enrollment, Your Lordship, kindly see, total 22 students. And what is the conclusion of the inquiry, Lordship? The conclusion of the inquiry is that, Lordship, on the above fact, Lordship, kindly come to page 93. On the above fact narrated, Lordship, because the other part of the inquiry report has been read by my friend, so I'm not going to read it again, Your Lordship. Yes. Only the conclusion, Your Lordship. On the above fact narrated, it may be concluded that the claim for payment of salaries filed by Srimati so-and-so do not have a valid ground and should not be entertained as their service was rendered in another school. The report of the inquiry, Your Lordship, is very clear, Your Lordship. They rendered the service in an unrecognized school, having no money, approved money committee. So my humble and respectful submission, Your Lordship, by their own conduct, Your Lordship, from 2008, Your Lordship, can you see, from 2008, they have already left the school. They have the freedom to do so, Your Lordship. They have the freedom, Your Lordship. So in my humble and respectful submission, Your Lordship, that order of suspension, Your Lordship, it merged, Your Lordship, with their abandonment of service. They were suspended. The so-called suspension was done in 2013, Your Lordship. But the fact remains that they were not in the legally recognized school with effect from 2008 till 2014, Your Lordship. So voluntarily, Your Lordship, they have left the school to render the service, Your Lordship, in another unrecognized school, Your Lordship. So, Your Lordship, the report of the inquiry is very clear, Your Lordship. My Lordship, they have no case, Your Lordship. They have no case, Your Lordship. That order of suspension become redundant, Your Lordship. It become redundant by their own conduct, Your Lordship. The money committee, as Lordship, I admit that inspector of school at that relevant time ought not to have issued that order, because, Your Lordship, as I have submitted, Your Lordship, they left the school. They already left the school in 2008, Your Lordship, to set up another rival school. As I have submitted, Your Lordship, they have the freedom to do so, Your Lordship. It is a clear case of abandonment of service, Your Lordship. They left. Lordship, to support that, Lordship, I would. Then another aspect, Your Lordship, which my friend has referred to the judgment of the Honorable Supreme Court in Ajay Chaudhary, Your Lordship, and so also the rule. Those judgment and that rule will be applicable only, Your Lordship, if both the writ petitioner, Your Lordship, render their service in that legally recognized school. It will come into play, Your Lordship. It will come into play. But that is not the situation here, Your Lordship. The situation here is that both the writ petitioner voluntarily, willingly, they left the school, Your Lordship. They abandoned that school to join to set up a rival school. 2008. Lordship, I'm citing this 2008, Your Lordship, para 10, 2008, 10 SCC 115, Your Lordship. Lordship, kindly come to para 12. Kindly come to para 12. When a government servant, Lordship, abandon, Lordship, kindly come to internal page 123, Your Lordship, at paragraph 12. That is, Lordship, I'm giving the wrong copy.
No, give extra copy.
Oh, I'm sorry, Your Lordship.
I know.
Lordship, kindly come to para 12 at internal page 123.
Yes.
When a government servant abandons service to take up alternative employment or to attend to personal affairs and does not bother to send any letter seeking leave or letter of resignation or letter of voluntary retirement, and the record do not show that he is treated as being in service, he cannot have after 2 decades represent that he should be taken back to duty. Nor can such an employee be treated as having continued in service, thereby deeming the entire period of qualifying service for the purpose of pension, Lordship. When an employer unauthorized absent himself and suddenly appear after 20 years and demand that he should be taken back and approach the court, the department naturally will not or may not have any record relating to the employee at the distance. In such, when the employer fails to produce the inquiry and the order of dismissal, the court cannot draw an adverse inference against the employer for not producing the record, or direct incident with back wages for so and so, ignoring the cessation of service or the lucrative alternative employment of the employee. Misplaced enmity in such matter will encourage the indiscipline, lead to undue enrichment of the employee at fault, and result in drain of public exchequer. Many a time, there is also no application of mind to the extent of financial burden as a result of the routine order for back wages. So, Lordship, in this case, Your Lordship, this is squarely applicable in this case, Your Lordship, because both the writ petitioner, Your Lordship, they left the school and joined in another school, Your Lordship. Then, Lordship, another. Lordship, another decision, Your Lordship. Lordship, kindly come to internal page 256, Your Lordship, at para 11.
Yes.
Para 11, Your Lordship. Even otherwise. Even otherwise, the petitioner was asked to continue in service till the decision is taken in this application. However, he did not attend the office of the respondents after so and so. Lordship, may I pause here, Your Lordship? Then, Lordship, kindly come to page 42 of the writ petition. The petitioner, Your Lordship, were directed by the authority, Your Lordship, to submit the joining report, Your Lordship, where? In the Roman St. Mary's RCLP School, Nongwai. She did not report there, Your Lordship. She did not report there. Rather, Your Lordship, went to another school. Then, Lordship, kindly come back to the judgment.
Yes.
Lordship, kindly come again to para 11, Your Lordship, at internal page 256.
Yes.
However, he did not attend the office of the respondent after so and so. In view of the above, as the petitioner had voluntarily abandoned the services of the respondent, there was no requirement on the part of the respondent to pass any order whatsoever on his application, and it is clear-cut case of voluntary abandonment of service, and the petition are liable to be dismissed. Then, Lordship, kindly come to para 12. It is a settled law that an employee cannot be termed as a slave. He has a right to abandon the service anytime voluntarily by submitting his resignation, and alternatively not joining the duty and remaining absent for long. That is the case here, Your Lordship. That is the case here, Your Lordship. Can you see, Your Lordship, from 2008, 2009 till 2014, Your Lordship? Absent from duty in the beginning may be misconduct, but when absent for a long period, it may amount to voluntary abandonment of service, and in that eventually the bond of service come to an end automatically without requiring any order to be passed by the employer. In so and so, Your Lordship, there should be a class where long unauthorized may reasonably give rise to an inference that such service is intended to be abandoned by the employee. Then para 14, Your Lordship, for the purpose of termination, there is to be a positive on the part of the employer, while abandonment of service is a consequence of unilateral action on behalf of the employee, and the employer has no role in it. Such an act cannot be termed as retrenchment from service. Then para, Lordship, I need not refer. These are the reiteration of by the Honorable Supreme Court, Your Lordship, rendered in the earlier cases, Your Lordship, with regard to abandonment of service. So my humble and respectful submission, Your Lordship, is that the writ petitioner, Your Lordship, they have no legally enforceable right, and both the writ petition are liable to be dismissed, Your Lordship. That's all. Oblige, Your Lordship.
My submission will be very short.
You're for the managing committee?
Yes, I'm for number 6.
Yes.
The petition has been filed filed after 7 years of lapses. There is no explanation in the petition why they have taken 7 years to come to this. So delay lapses. Maybe of that case only. Second point that I would add further is that the worship would consider the question of recalling sought by the petitioner will only come into picture if they can make out a case that the inquiry report is wrong, that they never left the school, they never abandoned the school, they are continuously teaching in my school. If they establish that one, only one Lordship will think that the inquiry report, and the consequence of recalling or setting aside the inquiry report would be recalling my suspicion. Therefore, petition has to make out that case. My upper submission is that the petition they fail to make out. Even my learned friend is not advancing that the finding of the inquiry officer is wrong. They are arguing. There is no material to please. So, first is limitation, we can go. Second, on the merits, petition is unable to establish, to interfere with the inquiry report. So, it will go. In case if Lordship is satisfied, it is maintainable, delay is acceptable, the inquiry report is illegal, and question of setting aside the suspicion for account. In that case, liberty may be given to the managing committee to conclude the inquiry. Otherwise, purely
see, but the crux, see, the crux of the matter here, if I can understand correctly, is the grievance of the petitioner as far as the the suspension proceedings are concerned. You have placed them under suspension, approved by government. At this point of time, I don't know whether it's relevant or not to say that that whole process was, was not legal, misplaced, whatever. We'll come to that later. But the fact of the matter remains that the suspension order was issued. Proceedings have not yet been initiated. I think we know very well, see, what entails a suspension proceedings.
That is true.
Filing of charge sheet, filing of a statement of charges, then reply, then presenting officer, inquiry officer, so on and so forth. But that process has not been gone through. So how do you explain that?
Right. My explanation here is, madam, here the suspension order was not supposed to be issued. They have left the school. But anyway, they have issued. I cannot dispute that. This is my own order. Now, after suspension, what happened? There was a thorough inquiry pursuant to the direction of this. And they came to a finding that they left the school from 2008 before I issue a suspension order in 2005. So therefore, they made a conclusively ended.
But you see, if I, sorry to interrupt you, but wasn't it not incumbent on you to take note of the inquiry report and say that in view of the inquiry report, they have been deemed to have abandoned their employment, suspension process is redundant.
Right.
That was not
right.
there.
For fairness of the managing committee is supposed to take note of that finding in pass a final order. That was not done. If that is not done, my lord, just continue.
So what is the consequence then?
Now the consequences would be therefore they would challenge if they are never in service from 2008. During my suspension in 2013, so they were not in service. So if I do not take any decision,
yes,
after the inquiry officer redone a first finding against them, we have to approach before this
in suspension order was dated
2014. It should be because their recommendation is on 2013, Your Lordship. On no 2000.
Page number 83, 86.
Anyway,
July 2013, my lord, and approved in January 2014.
Okay.
And they are filing.
So from 14 they have come before the court in 20.
20.
So that you have not explained that.
No explanation, Your Lordship.
2013. Now 2014 inquiry report came. Adverse to them. They didn't challenge an inquiry report of 2013, 14, 15. nor challenge my inquiry. So if I didn't take any steps, they ought to come before this court. This is going on, this is illegal. They're not passing any order, managing committee, and then inquiry reports refers to me, lordship internet. We should have sought that remedy. They didn't do that. They kept silent for 7 years and came 2010. No explanation, lordship, I understand. That's why they take 7 years to approach it.
True.
Suffer from delay.
The issue of delay and latches will be looked into. But again, you see, how do we reconcile the fact that you have also failed in your duty?
Yeah, that part is. Therefore, in case if lordship is overruling my contention, then lordship may interfere with the.
You see your lapse, whether it can be translated into benefits that it has accrued to them, as far as subsistence allowance is concerned. Now, here they have, you see, if I understand correctly, they have clearly stated that they are not insisting on salary. Of course, the principle of no work, no pay will come, whatever the case may be. But as far as subsistence allowance is concerned,
Subsistence allowance would come when they were suspended after when they served from the school. So if they left the school.
Okay, because
if they left the school 2008.
2008, 2009.
8-9 they left the school. And suspension took place in 2013. So therefore, question of subsistence allowance come that they were serving in my school and placed them under suspension in 2013 on the grounds of accusation. Then duty cast upon the managing company to pay them subsistence. So 2-3 falls prior to that, they left the school. And because of that, the inquiry report came to finding that they left the school in 2008. So there was no question of paying subsistence allowance to employees who left the school, the institution. That's my contention. So if my friend can make out a case that the inquiry report is illegal, and lordship is nullifying that inquiry report, then in that case, lordship would examine as to whether the entitled for subsistence allowance. My humble submission is they got it because of the abundant service following the decision. My short search.
yes, I think.
Yes, my lord. Few things, my lord. On the point of delay, my contention is, my lord, that the suspension is continuous, my lord, and indefinite. So there's a continuation, my lord, in the cause of action. Number one, my lord. Number two, if your lordships kindly have my writ petition, the last communication that was made to me was, my lord, in August 2015, rejecting for payment of salary, my lord. Now I'm not claiming the salary. The previous writ petition filed by me was for the salary. Report says you are not entitled to salary. They have communicated to me that you are not entitled to salary. So I'm not pressing on that. Now, what happens is, during the pendency of the writ petition, there's a suspension order, my lord. Thereafter, once a suspension order comes into place, my lord, I was not allowed to join the school. Despite the issue, it is very clear from the report that the dispute was, my lord, settled by the commissioner only in March 2013. So the contention by the state saying that that is a fake school, that was settled only in 2013, my lord.
What are those terms of settlement? How was it settled?
Settled in a sense, my lord, whatever inquiry was conducted.
Have they reconciled, or was it decided that one school will do away with its identity and then the other will
Yes, my
remain?
lord. It would mean that it has been given in favor of the other party, of Mr. Sangreso. So that was decided as late as March 2013, and it is thereafter that I've been suspended, and it has been continuous. Now, the suspension order, the resolution was passed in July 2013. Approval came in 2014 January. Now, pursuant to that, pursuant to the report, the communications from the department, as late as 4th of August 2015, saying that you are not entitled to salary. So I'm not pressing for that, my lord. Now, in the meantime, my lord, 2 years passed by, my lord, 2015-16, and then in page 97, I then file a RTI, my lord, seeking for clarification, what is my fate as on today, my lord. And I have raised question whether I have been terminated, whether disciplinary proceedings have been conducted. So all these questions have been answered by them, my lord. This is 2019. In 2019 November itself, saying that my lord, page 97 is the RTI, my lord. So question number 5, my lord, whether the teachers have been suspended. Your lordships has annexure 30, page 97.
Yes, yes.
Question number 5 is whether these teachers have been suspended. If yes, on what date? Whether they have been terminated. If yes, on what date? Whether any departmental inquiry has been conducted against these teachers. Whether salary has been paid. So the answer is on the next page, my lord. To number 5, your lordships will see. To the question number 5, they say teacher has been suspended by the managing committee of the school and approved by the SDSEO, copy and close. Number 6, teacher have not yet been terminated. And then at 7, they say departmental inquiry against the teacher has been conducted. It is only thereafter, my lord, at page 99 I make a representation, my lord.
Lordship, that application is done
I
by,
didn't
somebody.
I didn't disturb you. So I make a representation, my lord, at page 99 for revocation of suspension and release of subsistence allowance, which is at page 101. Page 99, and my last paragraph will be at page 101, para 10. This is in February 20, my lord. To revoke the suspension. And page 102, my lord, they reply to my representation, but making no sense, my lord. They just say they're forwarding something. They're forwarding a letter of the director, but which is not nothing speaking in the order, my lord. Your lordships kindly have page 102.
Yes.
This is a reply to the petitioners. The subject is representation for revocation of suspension order and release of subsistence allowance. It says, my lord, with reference to the subject cited above, I am enclosing herewith copy of letter so-and-so dated 6th of October 2020, along with letter number so-and-so dated 10th of August 2015, along with the file note for the director of school so-and-so, which is self-explanatory. And so the letter which they speak about 6/10/2020 is at page 103.
Yes.
It says, my lord, with reference to the subject cited above, I am forwarding herewith a copy of the letter mentioned along with the file note regarding Writ Petition 184 and Writ Petition 185. This is for your information. So they're just forwarding, my lord, without any...
What is that? Where is this letter? I am forwarding here a copy of the letter mentioned.
10th of August.
Where is this letter? You have not enclosed.
I'll just. It should be somewhere. This dates. 10th of August 2015. Your lordships will find at page 96. Page 96, minute. So this 2015 order was enclosed. This is dated 10th of August 2015. So this is the rejection of the payment of salary. So, my lord, despite my representation, they did not reply to the prayer for revocation of suspension, my lord. They just forwarded a letter saying you are not entitled to the salary. Salary for which, my lord, I am not claiming as on today, my lord. And, my lord, the other points which was been argued by the state regarding the delay, my lord, or regarding that there's no requirement to pass any order pursuant to what has happened, but there's nothing on record to show that whatever suspension order has been passed and approved by the department, that any subsequent order has been passed to say that it is recalled or this is not required. So, my lord, the suspension order is in continuation, my lord. Now, my lord, I'll reply to what the learned senior, Mr. Sangreso, had argued on the point of liberty to conduct the DP, my lord. Now, my lord, we are before your lordships only to set aside the prolonged suspension. If they wish to conduct a DP, they do not wish to conduct a DP, it is up to them. And by granting them liberty to do so, my lord, your lordships cannot take away my right to raise a ground that delay in conduct of my lord, DP vitiates the entire proceedings, my lord. So it is up to them. If they want to conduct, they may conduct. If they do not wish to, they may not conduct. So, my lord, no liberty may be granted from this honorable court. They are at liberty to do whatever they want, my lord, and I should also be at liberty to reply whatever is permissible under law, my lord. That is a submission.
May I reply on a little, your lordship? Lordship, that order of suspension, your lordship, done in become redundant and it merged with the lordship with the letter 10 August 2015. Lordship, kindly come back to page 96. What did they say, lordship? Lordship, lordship, first paragraph, then the letter say they left their services. Lordship, lordship, it say like this. I'll read the whole, your lordship. With reference to the subject cited, subject and letter number quoted, I am to inform you that as per the Honorable High Court judgment dated so and so, Shri Prinksad, Deputy Director of School, Shillong, conducted inquiry, and after being all fact and figure included that claim for payment of salary of so and so is unjustified and illogical, since they were not rendering their services in the school with January 2008-2009 respectively, that is at St. Mary's as School A, where they were originally appointed. They left their services school where they were appointed and went of their own to serve in another school, which is a private school not recognized by education. So it merged with this, your lordship. That is why the argument of the state is that they abandoned voluntarily their services, your lordship. Read further.
They left there.
But owing to the clerical so and so, Shillong was issued in this way completely in this one, and therefore is recalled under lordship by this 4th August 2015, lordship. There was a direction to issue or to release the payment of salary to them. So that has been recalled because it was issued by mistake. Rejected.
Salary rejected.
They left the school, your lordship. The sentence is very clear. They left the school on their own, your lordship. So it is a clear case of abandonment of service, your lordship, for which no relief can be granted, your lordship. Highly applied.
Lordship will require some note because I have a list of dates.
Please,
maybe I'll just.
If you can find your written.
Yes, ma'am. Short points. We'll do that.
Heard Mr. Piliwan Nungri, Learned Counsel for the petitioner. Also heard Mr. Andy Chulai, Learned AAG for the state respondent, and Mr. H.L. Sangreso, Learned Senior Counsel, along with or respondent 6 managing committee. Hearing is concluded. However, parties are allowed to file a short, a brief written synopsis of the argument within the next date fix. This is matter 1 week.
1 week.
This is matter.
Apply, Lord.
May I request my lord, can we inform each of the petitions when they reach superannuation age or how long they likely to serve in case lodged in the register? It seems that they are the agents.
What is there? Look. Wait, you have not mentioned age.
I'll just inform you, Lordship, because these notes was prepared by me some 2 years back, my lord. That time this particular petitioner was 54 years of age. So now she should be around 56. So just 4 years of service left. In fact, my lord, when this matter was heard by another bench, my lord, this honorable court had directed the parties to sit together to try and resolve, maybe a golden handshake. So at that point we agreed that okay, we can have a golden handshake, maybe some amount can be paid and we will my lord, settle. In turn, my lord, the managing committee was asking money from us, which, my lord, was very, my lord, we won't be in a position to pay them, my lord, and as so that is why, my lord, the petitioner in writ petition 456 should be around 56, and the petitioner in writ petition 455 would be around 49. I'll put it in a note, my lord.
Well, that wouldn't, if the court contemplates, allow the pay of the managing committee for future, action if so required. We'll see.
But, we're just happy that we have concluded the hearing in an old matter, my lord, and push it to your lordships.
True. These old matters are always hanging, and they have the tendency to, to go on and on and on.
As counsels also, my lord, we lose interest in all matters, reading again and again, my lord.
Thank you.
Deeply.
How are you, lordship?
On daily list, item number 1.
Yes, what is required here?
My lord.
What is required here?
It's ready for hearing actually. On the last occasion, my friend had taken some time.
Yes, it can be taken up.
Ready for hearing?
Yes. My only thing is time is running out. If it can be taken some other day, maybe. Also, my voice is sounding a little funny today.
2 weeks then. On prevent by the parties, let's just matter after 2 weeks.
Obliged.